Judiciary of India. The Indian judicial system is managed and administered by officers. Judges of subordinate judiciaries are appointed by the governor or on recommendation by the High Court. Judges of the High Courts and Supreme Court are appointed by the President of India on the recommendation of a collegium. The judicial system is structured in three levels with subsidiary parts. The Supreme Court, as known as the apex court, is the top court and the ultimate appellate court in India. The Chief Justice of India leads the court. High courts are the top judicial bodies in individual states, controlled and managed by the state chief justices. Below the High Court are district courts, also known as subordinate courts, that are controlled and managed by district and session judges. The lower subordinate courts are civil court and district municipal court, headed by a sub-judge. The higher subordinate court, criminal court, is headed by chief judicial metropolitan magistrates at top and followed by ACGM, ACMM and JM and MM at the lower level. The executive and revenue courts are managed by the state government through the district magistrates and commissioners respectively. Although the executive courts are not part of the judiciary, various provisions and judgments empower the High Court and session judges to inspect or direct their operation. The Minister of Law and Justice at the union level is responsible for raising issues before Parliament relating to the judiciary. It has jurisdiction to deal with the issues of any court. It also deals with the appointment of judges of the High Court and the Supreme Court. At the state level, the law departments of the state deal with the issues regarding the High Court and the subordinate courts. The Constitution and the judiciary. The Indian Constitution empowers the judiciary to act as a guardian of the law. A number of provisions deal with the judiciary's role, power, function, and officer appointments. The major provisions are Part 5, Chapter 4, Union Judiciary, there is Supreme Court, appointment, removal, rule, and function. Part 6, Chapter 5, High Court, appointment and removal, rule and function. Part 6, Chapter 6, Subordinate Courts, Appointment and Removal, Rule and Function. Article 50, Independence of Judiciary, separates judiciary from executive branch. Other provisions appear under parts and articles that deal with the court's responsibilities. The judiciary acts as the arbiter on legal matters. The inner conflict of constitutionalism, judicial review, and the basic structure. India's living constitution. Constitution acts as its watchdog by calling for security, for calling scrutiny any act of the legislature or the executive from overstepping bounds set by them by the Constitution. It acts as a guardian in protecting the fundamental rights of the people and as enshrined in the Constitution from infringement by any organ of the state. It also balances the conflicting exercise of power between the center and the state or among states. The judiciary is expected to remain unaffected by pressures exerted by other branches of government, citizens, or interest groups. Independence of the judiciary is a basic and inalienable feature of the Constitution. On such the protection is that no minister can suggest a name to the president, who ultimately appoints judges from a list recommended by the collegium of the judiciary. Judges of the Supreme Court or High Court cannot be removed from office once appointed unless a two-thirds majority of members of any of the houses of the parliament beg the move on grounds of misconduct or incapacity. A person who has been a judge of a court is barred from practicing in the jurisdiction of that court. Appointment. Under parts 5 and 6 of the Constitution, the President of India appoints judges of the Supreme Court and High Court with the consent of the Chief Justice. In practice, cultural norms are followed in the appointment of judges to the Supreme Court and High Courts. In accordance with the principles set forth in the three judges' cases, the President selects from a list recommended by the Collegium a closed group consisting of the Chief Justice and the most senior judges of the Supreme Court. Prior to the three judges' cases, the President appointed judges upon their recommendation by Union Cabinet. In 1993, as a result of the second judge's case, the executive was given the power to reject a name recommended by the judiciary. The executive has since faced criticism for its decision relating to this power. Decisions by the Collegium have been the subject of legal scrutiny. In Mahesh Chandra Gupta versus Union of India and Ours, the court held that who could become a judge was a matter of fact, and that any person therefore had the right to question the court's determination regarding a candidate's qualification. However, the court also wrote that who should become a judge was a matter of opinion and could not be questioned. As long as a judge's appointment is the subject of a legitimate consultation by the Collegium, the content or material it uses to form its opinion cannot be scrutinized by a court. In contrast to the historical norms concerning Supreme Court and High Court appointments for subordinate court judges are handled as prescribed under the Constitution and other laws and codes. Appointments are generally made by the Public Service Commission of a particular state. However, in some states, the respective High Court can appoint judges of subordinate courts. Regardless of the source of appointment, the process for the appointment of judges is the same and is based on the result of a competitive examination. Junior division or civil judges may advance to judicial positions in the provincial civil service, while entry-level district judges with at least 7 years of experience can complete the higher judicial service HJS exam in order to advance. History. The history of jury trial in India dates to the period of European colonization. In 1665, a petty jury in Madras composed of 12 English and Portuguese jurors acquitted Essentia Dawes, who was on trial for a murder of her enslaved servant. During the period of company rule in India, jury trials within a dual court system territories were implemented in India territories under East India Company EIC control. In presidency towns such as Calcutta, Bombay, and Madras, Crown Courts employed juries to judge European and Indian dependent in criminal cases. Outside of presidency towns, company courts staffed by EIC officials judged both criminal and civil cases without the use of a jury. In 1860, after the British Crown assumed control over the EIC's positions in India, the Indian Penal Code was adopted. A later year, the Code of Criminal Procedure was adopted. These provisions stipulated that the criminal juries were only mandatory in the high courts of presidency towns. In all other parts of British India, they were optional and rare. In cases where the defendants were either European or American, at least a half of the jury was required to be European or American men, with the justification given that juries in these cases had to be acquainted with the defendant's feelings and dispositions. During the 20th century, the jury system in British India came under criticism from both colonial officials and independence activists. The system received no mentions in the 1950 India Constitution and went unimplemented in many jurisdictions after independence. In 1958, the Law Commission of India recommended its abolition in the 14th report that the Commission submitted to the Indian government. Jury trials in India were gradually abolished during the 1960s, culminating with the 1973 Criminal Procedure Code, which remained in effect in the 21st century. The evolution of independent judiciary. The SEPRU Committee report published in 1945 considered the judiciary in detail and reiterated what the Government of India Act 1935 had set out. A Federal Court of India would be the forerunner to the Supreme Court. To separate the judiciary from the executive, the SEPRU Committee suggested that judges have fixed salaries and tenures, and that they could only be removed from for gross misbehavior. Judges were to be appointed by the President in consultation with the CJI. The committee appointed to deal with judicial questions as part of the Constituent Assembly in 1946 was influenced by SEPRU report, though there was concern over the power given to the President. Jawaharlal Nehru, however, supported the SEPRU Committee's proposals. In 1949, Nehru said that Constituent Assembly judges ought to be individuals of the highest integrity who could stand up against the executive government and whoever may come in their way. B.R. Ambedkar emphasized the need for official independence, stating there can be no difference of opinion in the House that our judiciary must both be independent of the executive and must also be competent in itself. Finally, the Constitution stated that every judge of the Supreme Court shall be appointed by the President by warrant under his hand and sealed after consultation with such of the judges of the Supreme Court and of the High Courts in the states as the President may deem necessary for the purpose. Given that in the case of appointment of a judge other than the Chief Justice of India shall always be consulted. Thank you, viewers.